Okay. Here we go. Let's go to page 17, please. And we're going to identify, I am DA, Mr. Graham.
I am the witness.
I am the court.
I am attorney for defense, Mr. Cole.
Okay, let's start on page 17, line 9, and that is Mr. No, it's not. It's Mr. Cole. And let's read in 15. I'm sorry, this one is a court. So sorry. You guys are so good getting all ready down there.
Judy,
And I slipped you a fast one. 15, this will be 210.
What did you say? What line?
9, that's Mr. Cole.
Mr. Cole, for the record, apparently there was a question in your mind for some period of time as to whether or not you were not going to.
We were conducting investigatory follow-up.
What sort of follow-up did you feel was necessary to be done?
Objection, Your Honor.
Sustained.
During the period of time that you were handling this matter, Mr. Ritchie, I assume at some point in time it stops being your responsibility. Is that correct, the prosecution of this case?
Well, I'm the supervisor of the division that's handling the case.
It no longer becomes your personal responsibility to prosecute the case at some point in time, I take it?
You mean where I appear in court?
Yes.
That's correct.
All right. And was that assigned to some other deputy attorney eventually?
Yes,
What deputy was that assigned to?
to Mr. Graham.
And would that have been after the complaint was issued?
I don't recall. It may have been contemporaneous with the time that the complaint was issued.
Now, up to that point in time, what steps did you or your office take to preserve any evidence regarding these charges?
Objection, Your Honor, calls for an ultimate conclusion of fact that's presented here. It's really, the subject matter of this goes to a conclusion.
Well, I don't know about that objection. It's a rather broad question. Any evidence? Your only concern is about the automobile?
That's what I'm going to nail down on, yes. I'm asking generally what steps were taken. I'm going to ask specifically what steps were taken as to the automobile.
If you want to nail it down right now to the automobile, go ahead.
What steps did you take to preserve the automobile, Mr. Ritchie?
I personally didn't take any steps to preserve the automobile.
Did you take any steps to make sure that the automobile was being preserved?
Certain agencies were photographing the automobile, were examining the automobile at some place in Stanislaus County.
Did you authorize the disposal of that automobile, Mr. Ritchie?
No, I did not.
Did anyone contact your office that you know of to ask if it could be disposed of?
Not to my knowledge.
Did you authorize its removal from Thompson Chevrolet?
No.
Generally speaking, Mr. Ritchie, are there any procedures in your office which are designed to ensure the preservation of material evidence in criminal charges such as this?
Objection, Your Honor, it's too broad of a question.
Overruled.
Where the evidence is in our custody, yes.
All right. You've got specific procedures for retaining evidence which has been delivered into your custody?
Into the district attorney's custody, that's correct.
And what about the evidence that is material and relevant but has not been delivered into your custody? Is there any procedure that for making sure that is preserved?
Police agencies have their procedures for doing the same.
As the office with the ultimate responsibility for prosecution of criminal cases, does your office have any procedures other than what procedures some other agency may have?
I'm not aware of any.
Does your office have a procedures manual?
Objection, Your Honor, it's not relevant.
Sustained. It's really too broad. I mean, they may have the procedure manual as to what secretaries have to do on filing papers and how they have to set up their headings and those procedures. Those procedures, I think, would be irrelevant.
Does your office have a procedures manual with regard to duties and responsibilities of the attorney's office?
Objection, Your Honor. Again, it's too broad. We're talking about 1538.5 motions, or are we talking about charging special circumstances, murder cases? It's too far broad.
I think that Mr. Cole is looking for is that there's a procedure in the district attorney's office for preservation of evidence, as that is held or retained or known about by other agencies other than the district attorney's office.
It's been asked and answered, Your Honor.
Well, Mr. Ritchie said he doesn't recall of any procedure, and I think Mr. Cole is trying to find out if there is one that he doesn't, that Mr. Ritchie doesn't know about.
Your Honor, I suspect it may be true there is a procedures manual and that there is no procedure such as I have suggested, even though Mr. Ritchie may be familiar with the procedures that are actually written down and formulated in the district attorney's office, that there is no procedure in that manual that he is familiar with dealing with preservation of evidence.
Well,
may I comment again, Your Honor?
yes.
Mr. Ritchie has suggested that he's not aware of any. All right. What I want to point out is that he is aware of the procedures manuals that they do have in the office, and it's not contained therein. Mr. Ritchie, just leaving it, he may not be. He's not aware of any, suggests it may be there, and somebody failed to tell him. I just wanted to clear up that point.
Your Honor, it's been asked and answered whether there's a procedure for the preservation of evidence in vehicular manslaughter cases. The answer that he's unaware of one, I believe that satisfies the question.
But if one in fact exists and he doesn't know about it, it doesn't answer the question by the defendant, is there one? If the procedure manual is 40,000 pages long, somewhere in that 40,000 pages, it may be in there, but Mr. Ritchie might not be aware of it. I think just to take an exaggerated example, if the procedure manual is 10 pages long and he's read the whole 10 pages and it's not in there, I think it would be easy for him to say it's not there. The answer implies that he doesn't know whether one exists or not. He's not aware of the procedure requiring the preservation of evidence held by other agencies.
Your Honor, the people would also object on the grounds that this falls into the confidentiality of procedures in the office and really kind of goes way far afield as to what procedure in the office. And I believe that the government code provides a privilege for that material.
That may be true, but Hitch says reasonable procedures have to be set out from now on. I'm not necessarily satisfied in my mind that the district attorney's office has to set up procedures for all the law enforcement agencies within the county.
Well, Your Honor, in light of that, the people would request an in-camera in order to go for the court to be presented with the procedure manual for the court and for the court to make that determination. I really think that this is a violation of the OR going into the governmental privilege.
I think you're just a little ahead of yourself. So far, Mr. Cole hasn't asked for discovery of the procedure manuals.
Perhaps I'm anticipating his next question. I believe it would be 1042 of the evidence code, Your Honor.
Maybe I can get it another way, Your Honor.
All right, proceed and let's see.
Mr. Ritchie, are you familiar with whatever manuals and procedures manuals do exist within your office?
I believe I am.
And have you read those manuals?
Yes.
All right. And do any of the procedures manuals contain any regular procedures designed to prevent inadvertent or negligent disposal of evidence?
Objection, Your Honor, under 1042 of the evidence code.
Overruled.
It's difficult to answer without something like negligent disposal by whom. Certainly any negligent disposal by our office, anybody employed in the district attorney's office, yes.
There is something in the procedures manual that suggests that?
For evidence delivered into our custody, that's correct.
You're again talking about evidence delivered into your custody?
That's correct.
Would you address yourself in that respect to evidence that has not been delivered into your custody?
I'm not aware of any procedure that has to do with the evidence over which we have no control.
Would you say it's highly unlikely, Mr. Ritchie, that there is some formal written procedures for to ensure the preservation of evidence which has not been delivered into your custody and that you're not aware of it?
I'd say it's highly unlikely.
Would you be willing to say there is no such written procedure?
The subject is so broad, that's my only hesitation. You're talking about any circumstance of any possible other procedure which might hinge on this issue ever so slightly, so I can't make an absolute no.
All right. In your office, do you work in close harmony with and cooperation with various law enforcement agencies, including the Highway Patrol?
Yes.
And when you require further investigation from those various agencies, as a matter of fact, like in this case, was that done by your office or was that done by the Highway Patrol in cooperation with you?
Done by both.
Did you or anyone under your control, so far as you know, suggest or direct the Highway Patrol to retain the automobile as evidence that was involved in this case?
Objection, Your Honor, calls for hearsay. It calls for the ultimate fact, and I believe it's already been testified to by Mr. Thompson, that no one informed him. He had the care, custody, and control of that car, and no one informed him that it was to be preserved.
If that's an offer for a stipulation that absolutely no steps were taken to preserve the evidence, I'll accept the stipulation.
It's not an offer of stipulation. It's what's been testified to by a prior witness.
Ms. Reporter, would you read the question? Objection overruled.
The automobile was retained. It was being retained at a Chevrolet agency on the west side, all during the course of the investigation.
It was retained for a period of time?
At least into the month of December.
Was it then destroyed at your direction?
Certainly was not.
Was it retained at your direction?
All I can say is it was retained by the California Highway Patrol, and during that period of time, numerous people looked at it, examined it, photographed it, and so forth.
Your Honor, I'm going to object that this response is not responsive to my question.
Sustained.
Ask the court to direct the witness to answer the question.
Just answer the question, Mr. Ritchie.
Yes, Your Honor.
And what is your answer?
Would you repeat the question?
The question again, please, Mr. Reporter.
Not at my personal direction, no.
Back to the previous question. Did your office, withdraw that. Did you direct the Highway Patrol or any other agency to preserve the automobile that was involved in the accident in this case?
Objection, Your Honor, calls for knowledge. That's beyond. It calls for things that might be beyond Mr. Ritchie's knowledge, and he was responsible for. And he testified in his direct that he's responsible for overseeing of these, and he did not direct it to be done. And I think that fully answers all the questions.
Overruled. The question is directed to Mr. Ritchie himself, whether he made a specific order or not.
I had no contact with the California Highway Patrol regarding where that car was or how long it would be there, no.
To your knowledge, Mr. Ritchie, did you or anyone in your office take any steps to make sure that the automobile in this case was preserved?
I did not. It was not under our custody.
To your knowledge, did anyone in the district attorney's office make such an offer?
No.
Thank you. I have no further questions.
Redirect.
I have no further questions, Your Honor.
You may step down.
Thank you, Your Honor.
Mr. Graham, do you have any other witnesses?
No, Your Honor.
Mr. Cole,
Call Mr. Trees back.
come forward, please, and be sworn. You may be seated.
Please state your full name and spell your last name for the record.
Robert E. Triebach. The last name is spelled Triebsch.
Mr. Trebesh, are you acquainted with Charles Stanley Cox, who's the defendant in this action?
I am.
What's the nature of your acquaintance with him?
Mr. Cox is married to my neighbor's daughter.
And how long have you known Mr. Cox?
Probably 3 years.
Are you also an attorney, Mr. Trebesh?
I am.
And do you practice criminal law?
No.
Did you become aware that Mr. Cox was involved in an accident on September 27, 1978?
Yes.
And as a result of that, did you make certain inquiries of the district attorney's office?
I did.
Did you make contact with Mr. Glenn Ritchie, who just testified?
Yes.
And did you advise him of the nature of your interest in this case, Mr. Trebesh?
Yes.
Would you tell us what you advised him?
Well, my initial contact was with Mr. Graham, who referred me to Mr. Ritchie as a person who worked in this area. I explained to Mr. Ritchie that I was a friend of the family and that this accident had occurred, that I did not practice in the criminal law area, and that my involvement in this situation was to ensure that whatever criminal and civil actions might be coming out of this accident, that Mr. Cox could be placed in the hands of people who would protect his interests in this situation, because I also do not practice personal injury law.
And upon your first contact with Mr. Ritchie, did he advise you that yes, Mr. Cox was going to be prosecuted for 4 counts of misdemeanor manslaughter?
No.
Did you talk about that possibility?
I asked at that time if he could give me an indication of whether or not criminal charges would be filed against Mr. Cox. He said at that time he could not because the investigation was still in process, and that he would contact me at a later date when he felt that he was in a position to make that opinion.
Okay. And is it true that your first contact was 10 days, a couple weeks after the accident?
Yes, it was approximately the mid part of October.
Even at that time, Mr. Ritchie advised you that they were unsure as to whether or not any prosecution was going to be filed.
That's correct.
Did you make contact with Mr. Ritchie at a later date?
Yes, I believe I called him on 2 or 3 subsequent occasions to inquire as to whether or not he had sufficient information upon which to make his decision, and he advised me that he did not, that the investigation was still incomplete, and he was sending it back for additional investigation.
And did you make a final contact with him?
Yes, sometime toward the end of November, Mr. Ritchie called me and told me that he was in a position to make a decision, he believed, and I requested a meeting with him because I had obtained certain photographs, and I said I'd like you to consider these before you make your decision as to whether or not to file.
Were these photographs taken by you?
Some of them were and some of them were not.
Were they photographs of the accident itself?
No,
Photographs taken at some later time?
they were photographs taken at a later time.
Showing the area of the accident, I take it?
That's correct, and I took photographs of the accident scene and of the tractor sometime after the accident and before the mid-October date when I met with Mr. Ritchie, and then I requested that Mr. Cox take some night photographs showing the lights on the back of the tractor.
Okay, we're going to stop there. And we are going to do, just so I can include it on our recording, which I could probably do. No, I want to do it this way. We're going to do the CSR test first. And that way I will include it on this recording, and then this will be uploaded to the site with the CSR test on it. This is a cool question. So we have a little bit of warm up first. And it is a deposition. A lot of that was at 2:10, so it probably did feel pretty fast. Brianna, are you going to the CSR? And if so, I'm wondering if you're interested in participating in any warm-up or having access to warm-up, let me know at the actual test. Oh, maybe I scared them both away.
You have that.
It happens. You get to do that when you're just chiming in online. Later. Can't do that when you're sitting in class. It's not easy. Okay. So we have Ms. Graves as the applicant's counsel. I'm sure right there that threw everybody. Oh, good, somebody is here. Okay, Brianna, I'll let you know after we get done with this. Okay, so Ms. Graves for the applicant's counsel, Mr. Baum for defense 1, Ms. Patrick, defense 2, and that's year 2, Judy.
Yes, ma'am.
And I'm going to go ahead and give you the preview words now because honestly, most of them are in the warm-up. There's very few in the actual test. So Mark Sims is the witness's name. Mr. Paul Nicholson Lumber, Mr. Scott, Susan Patrick, Mr. Jones, and OSHA. And I apologize in advance if I skipped one. I did this morning before class, so I may have skipped a preview word. I hope I didn't. But anyway, we're going to do the warm-up. It's 3 minutes, and let's read it in 15s. The larger marks in 15s, which will be 200. I am Ms. Graves for the applicant.
I am the witness.
I am attorney for defense 1, Mr. Baum.
Attorney for defense 2, Ms. Patrick.
And it's Mr. Baum questioning for the record. First of all, can you state your full name?
Mark Sims.
Now, you said that at some point in 2015, you were responsible for supervising people in the mill area. Is that correct?
That is correct.
When did this time terminate?
Maybe a year and a half ago.
Was it before or after the accident to Mr. Paul?
After.
Did the problem with Mr. Paul cause these duties to be removed from your job?
No, not at all.
Do you know who hired Mr. Paul?
How could that possibly be relevant to the lawsuit we are discussing? That is not relevant. Please move your questioning along, counsel.
Join in the objection.
That is all just for the record. Answer the question, please.
I do not recall who hired him.
Were you there when Mr. Paul was hired?
Working for the company at present?
At present.
No.
Do you know how it came to be that Mr. Paul was hired?
Objection irrelevant.
Mr. Sims?
No.
Do you know how many days Mr. Paul had worked at Nicholson Lumber before the accident happened?
A few days only.
What?
Excuse me, how many days is that?
Say 9 or 10 days.
Counsel, is the witness looking at a document to answer that question?
No, his testimony is from his memory, I think.
Okay, I would like you to test his memory, then show him documents.
Do you know under which person he worked before the accident happened?
Mr. Scott.
What was Mr. Scott's position?
He got all the jobs for the company.
What was he doing at the time Mr. Paul was hired?
Running projects.
What was Mr. Paul's job at that time?
Helper.
Did he work in the mill area?
I do not believe so. Not at that time. I am not sure.
What happened that caused Mr. Paul to begin working in the mill area?
I believe he was all caught up with his work with Mr. Scott and was over in the mill.
Under whose supervision was he in the mill?
He would have been under my supervision.
Before Mr. Paul started working in the mill, did you have an opportunity to discuss with him what his job would be in the mill area?
No.
Do you know if anyone on behalf of Nicholson Lumber spoke with Mr. Paul concerning his duties?
That I don't know.
Would you like to question the witness at this point?
In the interest of time, yes, I would.
Go ahead.
Thank you. Good afternoon, Mr. Sims.
Hello.
My name is Susan Patrick, and I have several questions for you regarding this accident.
Okay.
Did you assign Mr. Paul to the job he was performing on the day of the accident?
I did not.
Who did?
I have no idea.
Who, besides yourself, would have had the authority to assign Mr. Paul a job in the mill?
Mr. Jones.
Did Mr. Jones assign him to that machine that day?
I assume that he did, but I do not know.
Did you ever give Mr. Paul any instruction before he started to work in the mill area?
No.
Do you know if Mr. Paul had some background working with power saws before coming to Nicholson Lumber?
No, I had no knowledge. The background of Mr. Paul is something I did not know. I did not hire the gentleman.
Do you think it is dangerous to put an inexperienced man in the mill area?
I will object to that. It calls for supposition. I do not know what that means. I instruct him not to answer. Pause. Okay, so that was our 3 minutes. And now we're going to do a 12-minute exam. Okay, so we'll re-identify for you. And this is Monday, week 1. And I am Ms. Graves for the applicant.
I am the witness.
I am attorney for defense 1, Mr. Baum.
Attorney for defense 2, Ms. Patrick.
Okay, and just in case you guys would want to transcribe this, you can get the hard copy also off the board's website. If you're interested in transcribing it, it'd be a great thing to do this week. So here we go with Mr. Baum. And again, reading in 15s, the larger marks.
Okay, and it's Mr. Baum for the record. I really think he can answer the question. We can note your objection for the record, but I would like the witness to answer now.
I am sorry, but I forgot the question. Would you repeat it?
I will come back to that. I would like to first get additional background information. How long have you worked at Nicholson Lumber?
I have been working there for about 17 years now.
Were you hired as a supervisor or did you work your way up?
I started in the mill area, was transferred out, and then came back in as a supervisor.
And how long ago was that? When did you become a supervisor over the mill area?
Oh, that must have been around the middle of summer of 2015. I think it was June or July.
Please don't guess, Mr. Sims.
I don't believe he was guessing, counsel. That sounded like an estimate to me.
Well, what is your best estimate as to when you became the supervisor of the mill area?
June or July of 2015. I remember for sure it was summer.
Do you remember for what period of time you had been in charge of the mill area when Mr. Paul had his accident?
Not long. I think it was about 6 months.
Was it part of your job duty to ensure that he knew how to operate all of the machinery in the mill area?
No, I don't do the training.
Do you know how to run all the equipment in the mill area?
I do.
And you have never trained anyone on the proper use of the equipment?
Objection, that misstates the testimony.
It does misstate it. I will join in the objection.
Have you ever trained anyone on the proper use of the equipment in the mill area?
I have shown a couple people how to work it, but I have never been their official trainer. I was just helping out.
When you say helping out, does that mean someone else was responsible for the formal training?
Yes, exactly. I would just answer questions or demonstrate if someone needed help.
And how would you know if they needed your assistance?
Usually they would ask me when I walked near their area. Sometimes you could tell by looking that there was a problem.
Did you know Mr. Paul before you became a supervisor?
No,
Before he was hired?
I had never met him.
Did you know if he had experience on the equipment he used that day?
No.
Do you think a man without experience could be injured if he were working around this equipment without some instruction?
What he thinks is not at issue here. The important thing is what he knows.
Do you know if a man could get injured if he is working around power equipment without some instruction?
I object. Vague and ambiguous.
I guess so. I guess it is possible.
Is there some reason why you did not try to explain any procedures to Mr. Paul prior to the time he was hurt?
Only that I was busy with other things at that time.
Did you give him any written materials on safety practices at the company?
Do you mean did he do that himself or did someone?
I understood the question to be, did he do it himself?
That I do not know. Myself personally, no. I did not give him anything myself. I do not know if anybody else in the company did. We do not even have anything like that as far as I know.
Did you say there are no such items for your employees?
The witness may not understand your question. Please ask the question again.
Are there any materials on safety given to employees of Nicholson Lumber?
There is a book somewhere, but I have not looked at it. I just think it talks about our company, not safety.
Nothing further at this time.
Mr. Sims, I have a few more questions for you.
Before you begin again, for the record, I will object that this witness did not see the accident. He does not have any knowledge of the accident, and there is nothing else to discover at this time from this man.
We do not agree with or accept your statement. Are you going to let me continue?
Go ahead. My objection is for the record.
In the 4 or 5 months prior to the accident, what was the number of employees working in the mill area?
I object. Vague.
I do not know. I could say approximately, but I am not sure.
You were the supervisor. I think we are entitled to your best estimate.
But we are not entitled to a guess. Please do not guess or speculate.
He said he can approximate.
I would estimate approximately 5, 6, whatever.
Would that number change from time to time?
It would.
When a new employee came in, was there a procedure that would be observed in showing the employee what he was to do and how to do it?
That I do not know.
Were you the supervisor?
That is correct.
You mean you do not know what the procedure was?
That is argumentative. Do not answer the question.
Was there a procedure that would be followed in showing the employee what he was to do and how he was to accomplish it?
I am telling you, I do not know.
You do not know if there was a procedure?
Negative.
That is his answer.
That is what I'm trying to establish, counsel.
Objection. He has said it 3 or 4 times now.
Was there any formal training session provided to new employees?
If you know, only if you know.
No.
Now, you said there was some written material available that would be given to employees.
He did not say it was given to employees. I think he said some material may be available.
I think so.
Was there a process whereby that material would be given to a new employee?
Yes, all new employees or new people receive that, yes.
Who gave that to the new employees?
Either myself or the foreman. I am not sure.
What were these documents called?
I do not recall. They are put out by OSHA.
Do they concern safety?
Yes,
Do they tell employees not to wear loose clothing around machinery?
that is correct.
Do they say not to get close to any moving machinery?
That is correct. There are a number of things in there. I do not remember all that is in there.
Do you know if Mr. Paul was ever given such information?
I have no recollection.
Excuse me. Did you have that material in May of 15?
I think so.
No more questions at this time.
Mr. Sams, do you have a recollection of seeing the wooden guard that we have discussed at length today in place on the day of the accident, but before Mr. Paul was injured?
I do not know because I circulate through the mill area, usually not stopping at any one spot. I just keep walking back and forth all the time.
Who was responsible for the setup work for the machines in May that year?
Which machines are you asking about?
All of them.
The foreman.
Additionally, did he have to set up the planer?
I do believe so.
And was it up to him to ensure that guards were present on machinery?
Yes, ma'am.
Did you ever notice before the accident that Mr. Paul would run this machine without guards in place?
I did not.
Did it ever come to your attention on any machine operated by Mr. Paul that he would use that machine without guards present?
No.
Would you expect Mr. Paul to make sure all guards were in place before operating a machine?
That would be his job, yes.
Now, after the accident occurred, was there any talk among the employees concerning the lack of a guard at the time of the accident?
Not at all. Some of them speak Spanish.
Did anybody say to you that a guard popped out of the machine at the time the accident was occurring?
I do not recall being told.
Did you hear that if a heavier guard were present on that machine, that the accident would not have happened?
Not to my knowledge.
Is it true that after the accident, a heavier guard was installed on that machinery?
Are you referring to the weight?
I am referring to the strength.
Maybe you could clarify if he knows or if he is an engineer or understands what that means, whether he has any information.
Do you understand my question? Shall I say it again?
Yes, please.
Is it true that post-accident, a steel guard was put where this board was previously?
Yes.
Was that guard put in its place?
Yes, ma'am.
Besides the metal guard that I described earlier, which is now somehow bolted to this machine, was any other part added to the machine after that day to your knowledge?
Not to my knowledge, but my job is no longer in that division of the company, so I am not sure.
Counsel, how much longer do you have?
1 or 2 questions. Did you tell the insurance company how you think this accident had happened?
Not seeing the accident, I could only guess.
But when did you speculate as to the cause of this accident? Do you know?
After everything was over, after he was taken to the hospital.
Was an ambulance called after the accident?
Yes, we did call, of course.
Do you recall what you told the insurance agent?
No, ma'am, it was by telephone. I guess I told him the only way I thought the accident could have happened.
What was your impression of how Mr. Paul's accident happened?
The man was using a rag instead of a wire brush to clean out the machine.
Is it your impression that the machinery was in use at the time of the accident?
The power was not on, but the machine continues to rotate for a few minutes longer.
I object. That is beyond his personal knowledge. He is not an engineer.
All right, I have no further questions at this point.
I have a couple of follow-up questions.
Go ahead.
Oh, on approximately how many times did you see the machine slow down after the button was pushed to turn off the power?
I cannot say because I was not in the area at all times.
Would you approximate it is more than 5 times?
It would be speculation on my part,
No, do not speculate. Just if you can estimate.
not too frequently.
Mr. Jones is not an employee of Nicholson Lumber today, is he?
If you know what employee means.
No,
Has the witness stated that he was an employee? Is that the testimony of the witness at this time?
Where does he live today?
I do not know.
Does he live in the neighborhood?
I do not know. It is none of my business where employees of Nicholson Lumber live.
Okay. When this machine that was involved in the accident was received at Nicholson Lumber, did it have any instructions?
You mean this exact one? I think so.
Is it your belief that it was the duty of Nicholson Lumber to find out whether or not there were guards on the machine involved in this accident in May 2015?
It would have been their duty.
Did you say the plaintiff had taken a rag and did something he should not have done? That the rag became caught in the machinery, which pulled the rag and the plaintiff's hand into the machine, thereby amputating 4 of the plaintiff's fingers on his right hand?
I do not think I made that statement.
During the time you have been employed at Nicholson Lumber, how many machines have been purchased for the mill area?
All that are present there now. I think 10.
Were you responsible for setting up those machines?
Yes, I was, all of them.
Is it your belief that if any more guarding is required, it is your responsibility to see that it is installed?
If I am assigned to that area, yes, but as I mentioned, my job duty has changed.
Has anyone else been assigned that duty during the time you have been employed with Nicholson Lumber?
No one other than myself.
Have you carried out that duty on each and every time that a piece of equipment has been sent to your employer?
For the equipment that is there now, yes.
Do you think Nicholson Lumber relied on you to properly set up the machine that caused this man's accident?
Object to the form of the question. Vague.
I will withdraw the question. Did you yourself run this same machine for the purpose of running through it in order?
No, running that machine was not within my job duty.
Was this planer working when it came to Nicholson Lumber?
It was in pieces.
And I take it you had to put those pieces together to ensure that it would work?
Objection. Vague and ambiguous.
The foreman did help me.
And besides you and him, did someone else help you with this job?
No, no one else.
Did you have some written material at the time period in which you were installing this machine?
Not to my knowledge, but we must have used something.
Let me inquire. Do you recall seeing any paperwork that you remember you used in putting this machine together? Can you testify as to that?
I do not recall any documents. We must have had some documents. How else could we have put the machine together?
I do not know. That is why I am asking you. I understand you were not present the whole time the foreman was working on putting together this machine. I am trying to jog your memory.
I must not be recalling. We evidently had some type of paperwork for this.
Thank you very much, Mr. Sims. Those are all the questions I have now.
I will state for the record that this entire deposition has been over my objection, and I will say that I plan to move to strike this testimony. Well, how was that? Just gotta hit through those words that you don't usually hit. Is that what threw you? The machine guard, the steel guard, yeah. You know, it's really hard, really easy for me to say this because I'm not sitting there, but I mean, you just got to hit through them. You just got to hit something. I remember the word burn came up a bunch of times on the test I took, and I'd never heard it before. And it just, you know, I allowed it to throw me. And it's a one-syllable word, you know, guard. It's one syllable. You just got to hit it and move on.
Think. Yeah.
Yeah, don't think about it. Don't think about
what it is or anything.
Yeah.
Just write it.
That I completely understand. I will tell you from a reader's viewpoint, I think syllabically it was counted well because it was very easy to stay on time and to read. So this is going to be a big issue at the board's meeting, which, by the way, if you're at the test, you're welcome to go. That's a public meeting. And they're going to talk about the, I can show you the agenda. The agenda's online. They're going to talk about the, these last two tests, I think, also. So if you have anything to say about them, you know, you are welcome to express anything that you. Kate says to everybody that there weren't very many briefs. That's probably true. Seemed like every word was multiple strokes. Yeah. You took this one before, Kate, right? You did, I think. Wondering if it was any better or worse this time. Unfortunately, yes. The part that would be relevant to schools, they purposely did this. They didn't start, they're not going to start that until 1 because a lot of people don't, like, we're not going to be there, you know, in the morning. We don't get there till probably 11 by the time we actually get into the hotel. So they're going to take a lunch break. They're going to do some other stuff in the morning, take a lunch break, and then reconvene at, I think it's 1 or 1:15. It's interesting to see how they work. It's, you know, how, because they decide a lot of things that are relevant to your profession and to you as a licensee. So it's really kind of interesting to just sit in on it. And you can leave at any time. You don't have to make a commitment once you go in, whatever. Okay, so this is also another take, and we are going to do a 5-minute warm-up. So I'm going to continue to leave this recording for the 5-minute warm-up. And I am Ms. Wilson for the plaintiff.
I am the witness.
I am the attorney for Defense 1, Mr. Harris.
Attorney for Defense 2, Mr. Berry.
And we do have a 5-minute warm-up for this. So we're going to start, and we're going to read it in 15s. And Ms. Wilson is questioning. On the record. Okay, Ms. Holloman, will you please state your name for the record?
Donna Holloman Wishman.
And have you had an opportunity to discuss with an attorney about the purposes of a deposition?
Yes, with Mr. Harris.
He's representing you?
Yes, right.
All right, so he's your attorney.
For the record, I'm personal attorney for Mrs. Wishman.
And for the record, I'm personal attorney for Mr. Wishman.
All right, thank you. Now, when did you first meet Susan Rowan? And by that, I'm referring to someone you know as Susan, but we're not using any last names.
Okay.
Of either Susan or Terry, her mother, I mean, not her mother.
Her mother-in-law.
Or Beverly, who we're calling Beverly Joe, okay? So that actually, if you want to just refer to them by their first names.
I'll do my best.
Yeah, good.
Sue, I met in 1999.
Yes, okay. And how did you meet her?
She was dating Jean's friend.
And who was that?
Cleve Lauren.
And after you met her initially, did you have further contact with her?
Yes, ma'am.
What were the circumstances of that further relationship that developed?
She moved into my apartment and became my roommate along with 2 other friends.
And when was that?
September 2000 or shortly thereafter.
And were you dating Jean Wishman at the time?
Yes, Ms. Wilson.
Now, at that time, did you have any church activities that you did with Susan?
No.
Did you discuss religious topics with her?
Yes, ma'am.
Did you discuss abortions specifically? Do you recall?
Probably, yes.
So from approximately September 2000, you did discuss your views on abortion with Susan?
Objection. When you use the word from, you don't have any termination date there. Vague.
Beginning in September 2000, you discussed with Susan your views about abortion.
I don't recall specific discussions, but I'm sure that it was a topic among other things.
And at that time, did you become familiar with her views?
I don't remember specific quotations or specific conversations, but I know that the 4 of us living together were in agreement that no one had the right to take another human being's life.
Okay, and do you know whether Jean ever became aware of Susan Brown's views about abortion?
No, I don't know.
Did you ever discuss with Jean his feelings about abortion?
I don't know.
Excuse me, I have to raise an objection, evidence code 970 and 971 on both the marital privilege and the spousal privilege.
Okay.
I would certainly concur in that objection on the basis that if she reveals anything about communications with Jean, That prejudices the interest of my client, Mr. Wishman.
The marriage and spousal privilege. And what other privilege was that?
I said evidence code 970 and 971. I further raised the objection, Article 1, Section 1 of the state constitution.
Okay.
And I'd also raised federal constitution objections on family privilege.
There's a two-part objection there on the marital aspect, marital communication, and the privilege not to testify against one's spouse.
Okay, all right. At any time did you attend the same church as Susan Rowan?
In January 2001, she began attending the same church that I attend.
Do you know how it was that you learned of the existence of that church?
I had been attending it for approximately a year.
And do you know if you had any role in her decision to attend that church?
Indirectly, I introduced her to the man who became her husband.
And how did that introduction tie in her attendance at that church?
I was signing a special solo and she came to hear me sing, and her husband came to tell me I did well, and she was there, and I introduced them.
Okay, to another subject. Had you been picketing that day?
No, not that day.
Did you hear about it on the phone or in person?
On the phone.
And who was it who told you?
Sue.
Susan?
Susan, yeah.
Susan, okay. And was she upset when she told you?
Objection calls for speculation.
Okay, well, did you hear anything in her voice or anything in her voice that indicated to you she was upset?
Yes, she was crying.
And what did she say to you?
She asked me, what should I do? What should I do?
Did she tell you how she had heard that Beverly had been seen entering the health center?
I don't know that we've ever established that's what she said.
Oh, okay. Did you know before she called that Beverly had been seen entering the health center?
No, I didn't.
What was your answer?
No.
And how was it that you learned that Beverly had been seen entering the health center at that time at noon?
I asked her what she was talking about.
And what did she say?
You don't know?
And what did she say?
No.
Then what happened? And then I'm sorry. And then what did she say? I realize this is a while back.
Yes, it is.
So if you want to, I'm not suggesting by asking you this that you're telling me their exact words.
Right,
But just the gist of the conversation.
right. I believe she said Gene just called and he saw someone go in the center who might have been Beverly.
And did you respond to that?
If I did, it was probably, oh, really?
I see. And was there any further comment on her part?
She asked again what she should do.
Uh-huh. And did you respond to that? Do you recall any response you gave to her question?
I told her because of the stormy relationship between her and Beverly that it was difficult for me to give her any sort of advice.
Okay. We're going to do a 12